As Liz said, my name is Britt Berner, and I'm one of the attorneys at the Berner Law Group. It's very special to be talking to people through the Westhampton Beach Public Library today. As many of you may know, one of our three offices is on Main Street in Westhampton Beach, and it's a town that we love and we're happy to support. And it's a beautiful library, and we can't wait to get back in there in person again. So thank you to the Westhampton Beach Library for having us. Today we are going to be talking about estate planning in the new year. So what does that mean? And I spent some time thinking about that, and really what it means is just like every year that turns, we have our resolutions. We have, this year I want to do X, Y, I want to run a marathon. I want to make sure that I redecorate my house the way I wanted. And one of those things should be, I want to check up on my estate plan. So estate planning for the new year is really just revisiting, or for those who have never done so, starting to look at what their estate plan is, what they want it to be, and are there any changes that need to be made if you already have a plan. We also look at your estate planning in the new year as what has happened over the last year or a little more than a year that might change what your plan is. And I think everybody could agree that there have been quite a few changes over the past year. And so what we're looking at today is how those changes may affect the planning that you're doing. So obviously in this past year, we've had COVID. Not much to say about that, except it's changed how we look at things. It's changed our ability to see that things can change very drastically, very quickly. And having proper planning in place makes those changes a little bit easier and makes you rest a little bit easier knowing that you've gotten this planning done. We've had changes on the political spectrum. We've had changes to both federal and state law. And all of these things, in addition to changes in people's family structure and where people are living, we've had a lot of people contacting us recently that they used to split their time between Westhampton and somewhere else, and now they're full-time in Westhampton. And a lot of people are seeing that the market is changing and they're selling their homes that they've owned for a long time in Westhampton because the market's doing well for them, the real estate market. So all of these are changes that might make you want to look at your estate plan a little bit differently. When I'm talking about estate planning, I'm talking about a few key documents. And there's certain documents that will apply to almost everybody, and then there's other things that might not apply to everybody. When we do planning, we recommend that almost everyone, with the exception of very few people, have healthcare advance directives and a power of attorney. A healthcare advance directive is a healthcare proxy, and for some people, a living will. A healthcare proxy is a document that says who makes your medical decisions if you cannot make them for yourself, if you're deemed incapacitated by a doctor. Now, this could be a temporary incapacity, like you're under anesthesia or you are on a ventilator, or it could be a more permanent incapacity that's brought on by cognitive impairments through things like dementia or Alzheimer's or other similar illnesses. And so a healthcare proxy is just directing who is going to make those medical decisions for you. A living will is a document that says that you would direct your agent to have the power to withdraw or withhold certain medical treatments if you were in an irreversible state with minimal expectation or no reasonable expectation of recovery as determined by your doctors. So you're just using that document to empower your healthcare agent to make a decision and to guide them in making the decisions so they know that they're doing something similar to what you would do if you could speak up for yourself. A power of attorney is a financial document. It's a document that says who has access to your banking, who can do real estate transactions on your behalf, who could set up a trust for you, who could apply for Medicaid for you. All of these different things regarding your financial life are what the power of attorney controls. Every power of attorney that is appointed, each person that's appointed an agent under a power of attorney has the powers that are given to them in the document. So what you want to do is look at your existing power of attorney and discuss that with a lawyer and say, Are there things that I might want my agent to be able to do for me that they can't do with this document? And if you have a document from before 2009, there's very possibly a lot of powers missing because there was a big change in the law in 2009. One of the things that we're going to look forward to this coming year, which is going to change about halfway through the year, is that in December, a new power of attorney law was signed in New York State. Now, this change won't take effect until June, and there's nothing to do until June because you wouldn't sign a document under the new law until after it comes into effect. But if you have an existing document, that's going to be something you're going to want to look at with your attorney. Now, if you have one, it is not going to be invalid by this change of law. It will still be valid as long as it was valid under the laws that were in place when you signed it. But if you don't have a power of attorney, you want to make sure that if it's after June, the attorney that you're working with knows that there's some drastic changes in the law regarding how the document is structured and regarding where you will sign and how many witnesses. And these are the types of changes you want to make sure that your attorney is aware of when you're signing a new document. One of the other big changes in the law, which I think is great for specifically the ALS community, but other communities where people have a mental are mentally competent and able to say that they, or to express that they would like someone to act on their behalf, but they're physically unable to sign the document. And this new law actually gives provisions for how that should be handled and how that person can properly have a document signed. And so it's going to be a really important thing for certain communities and certain people who up till now have had issues with the physical signing of the document. The other thing that this new law is going to do is it's going to put a little bit of teeth in the law in terms of banks complying with the power of attorney document and not just rejecting them and saying that they're too old or some other reason that is not a reasonable reason to reject the document. And so this is going to be a change in June that we're going to want to look out for, and we'll certainly be talking a lot more about it as time goes on. While that law was signed in December, there are some amendments that we already know are being introduced up in Albany that we expect to be passed to alter a few and fix a few things that the legislature thinks was wrong with the initial law, the way it was written. So stay tuned for that. The other documents that people should have are a trust or a will or a will and a trust. So what does that mean? So a last will and testament is a document that says how your assets are to be distributed after your death, who it should go to, should it go to them outright or in a trust, who will be the executor. It might say that you want your house to be sold and the assets distributed. It might give certain jewelry to certain people. All of this is within that will document. But a will requires a process with the court called probate. And we've done a lot of talking about this in the past, so I'm not going to go too much in detail for the sake of getting to other things. But if you are a person who owns property in multiple states, or you're disinheriting one of your children, or you're disinheriting your spouse, you may want to avoid that probate process. And there's some other people that fall into the category based on the circumstances of their life that might want to avoid that court probate process because of the cost and expense of it. And so for those people, very often, especially if they own property, they are going to want to do a trust. Now, there's many different types of trusts, and they're done for all different reasons. But a trust document does not mean you shouldn't have a will. If you have a trust, we often will still create a will, even if that will only says all of my assets should be put into my trust. And so it's important to sit down with your attorney, with your financial advisor, with your accountant. And if you've listened before, I say this all the time, with your advisors, whoever those people are in your life, you should be sitting down with them and discussing what the best plan is for you. And so I would say that estate planning in the new year, we're looking at how have the laws changed? How are they going to be changing moving forward? And how does that affect me? And those are the questions that you should be asking to discuss with your different advisors. Every year, the exemptions for the estate taxes change. So this year for 2021, in New York State, we have a $5.93 million exemption. That's per person. So that means that each individual can die with $5.93 million in their name, and there will be no estate taxes paid. Now, it's important to know that in New York State, we have something called a cliff. So what that means is as you get up to 5.93, there's no tax. But once you hit 100% of that number, you fall off the cliff and taxes are owed back from $1. So when we run the numbers, you're looking at, if you're below that number, having no estate tax. If you're just above that number, maybe having a few $100s in estate tax because you're only paying on the amount that you've gone over. But once you hit 105% of that number, you're talking about a potential of hundreds of thousands of dollars in estate tax. And so again, if you're someone who's close to that number, that 5.93, you're going to want to do planning to make sure that those that you're leaving things to, your beneficiaries, are spared from a large estate tax. Now, sometimes we can completely wipe out any estate tax that's owed, and other times we're really just trying to be tax efficient to minimize taxes and to minimize waste on the estate. And certainly if you have two spouses and one spouse has the bulk of the assets and the other spouse doesn't have very much, but if you add it together, it's over the 5.93, you're going to want to do planning that makes it so that whichever spouse dies first, they have the use of both exemptions. And now you're looking at almost $12 million in exemption in New York State because you're sharing the exemption between spouses, as opposed to just a 5.93 for the moneyed spouse. This is stuff that has to be done through your planning because in New York State, our system is a use it or lose it system. So it's not like if the spouse with all the money dies or the spouse without the money dies first, there are exemptions left over for the other spouse. That is so in the federal government, but that is not so in New York. And so you really want to make sure that, again, you're doing proper planning in that regard. In terms of the federal government, we currently have an $11.7 million per person exemption from estate taxes. Now, the difference there, obviously, other than that it's a much larger number, is that the 11.7 million is in life and death. So if you gave away $2 million and then 5 years later you die, that 2 million gets counted towards your 11.7. And so again, that people who have assets that are hitting those levels, gifting and the estate should be done as part of a larger plan to make sure you're being efficient tax-wise and to make sure that the money is there and the liquidity is there to pay those estate taxes if there are any owed at death. In New York State, we don't have a gift tax. So if you give away $2 million while you're alive, as long as you live for 3 years past when you gave that gift, there's never a tax on that money. And so there's a big difference between the federal system and the state system. And again, you're going to want to get the proper advice for your estate to make sure that even as those exemptions are changing, you're doing what's best for you and for your beneficiaries. Now, the current law and the federal government has 11.7 million as our exemption right now, and it's indexed for inflation, so it will presumably continue to go up. However, in 2026, for those that die in 2026 or later, the federal Tax Cut and Jobs Act that was signed while President Trump was in office said that that law sunsetted for those who died in 2026. So what that means is after January 1st of 2026, if you die, your estate tax exemption is not going to be over 11 million. It's going to go back to the number, which is probably going to be right around 6 million, right around what New York State is. And so if you are someone who is going to have one of those larger estates, you're going to want to plan for that sunset. Further to that, with the new president and vice president that we have, we've seen when they were campaigning that one of the things that were discussed was lowering the estate tax exemptions. And so while the current law is set to sunset at the end of 2025, it's very possible that that number could go down sooner. So this is something that, again, if you're in that higher tax level in terms of estate taxes, you're going to want to be keeping up with your advisors and making sure that they're on the cutting edge of figuring out what can be done to minimize the tax on your estate while the exemptions are very high. Another big change that happened on the federal level over the course of the last, well, now it's about 13, 14 months, it was in December of 2019, was that there was a law called the Secure Act that was put into place, and it made big changes to how people can leave behind retirement assets, tax-deferred retirement assets. So you can think about your traditional IRA, your 401k, your 403b, your 457 plans, those tax-deferred accounts that you have. One change, which is affecting those that are alive, is if you haven't yet started taking your required minimum distributions because you were too young to do so, you now don't have to take those until you're 72 years old. They used to be required at 70 and a half, and they've raised that age. So that's one change for while people are still living. But the big change and the big headline on the Secure Act is it's changed how you can leave behind assets to your beneficiaries that are other than your spouse. So I'll give an example. If I leave my retirement account to my spouse can roll it over and they take required minimum distributions, and it continues, the rest of the account continues to grow tax deferred. Before this law change, if I left assets to my children or to another beneficiary, it would be the same thing. They would roll it over into an inherited IRA, and they would take distributions on their own life expectancy. So say I'm 80 years old when I die, my child that I'm leaving it behind to might be 50 years old. They're going to have a 40+ year life expectancy, and so that their distributions are going to be much smaller than what I was taking while I was alive, and that account's going to continue to grow tax deferred for a long time. What the Secure Act did was it took away that lifetime stretch for all but a few beneficiaries, and there's a few exceptions, but for the most part, for your children or your other beneficiaries, not spouses, you will have a 10-year forced payout on those accounts. So my 50-year-old child that I'm leaving that asset to will have to take out that entire tax-deferred amount by the time they're 60. They've got 10 years to do it. They can do a little in year 1, nothing in year 2, a little in year 3, and empty it all out in year 10. Or they could divide it by 10 and take it a little at a time. They'll have to determine what's best for them, because that's all taxable income to them. Because remember, these are tax deferred accounts that you never paid income tax on. And so the big difference is that now that your beneficiary, who might have been able to stretch those payouts over, say, 30 or 40 years, now has to take those distributions within 10 years. That's a lot more tax that's going to have to be paid up front by those beneficiaries. Now, whether or not there's something you can do to stop those taxes from being levied upon those beneficiaries and what kind of planning you could do is going to depend very personally on your situation. For some clients who are charitably inclined, there's certain planning we can do to divert those taxable assets to the charities. For those who have certain beneficiaries who are in the exempt categories, you can possibly give retirement assets to an exempt beneficiary who's allowed the lifetime payout. And then for others, the answer is going to be, well, they're just going to have to pay the taxes when they receive these monies, and that's okay, but better that they be informed and that you be informed of what is going to happen with those assets after you're gone, so you understand the implications of what you're leaving behind. The other, and I'll say the last change that I'm going to discuss today is on the state level. Now, on the state level, we had very large changes signed into law in April to our community Medicaid program. That's our home care Medicaid program. So those who are receiving assistance from an aide in their home with their activities of daily living. The budget that was signed in April, signed by the governor and passed by both houses of our New York State legislature, was a big change on the financial side for Medicaid as well as the care side. So on the financial side, they have added a 2.5-year look back for home care Medicaid applications. So what that means is that they go back 2.5 years from when that application is made, and they look at what transfers of assets were made and impose a penalty period, and those are months that Medicaid won't cover the cost of care. We've always seen a 5-year look back for a nursing home Medicaid. So this isn't that surprising that eventually they would catch up and have one for community Medicaid. And most other states do have a look back for community Medicaid, but New York never did. And so we would have people who might come to us in, say, January and say, my loved one or for myself needs home care. What can we do? And we could transfer the house to an irrevocable trust. We could transfer some cash out of their name, and they could qualify for benefits the following month. That's no longer possible under these new laws. So now you're going to have to do more advanced planning if you are concerned that you're not going to be able to cover the costs of your care and that you might need the Medicaid program. You're going to have to do some more advanced planning to protect certain assets. This law has not yet been implemented. So the law as signed said that it would be implemented on October 1st of 2020, but due to federal money that we get based upon the fact that we're in a COVID state of emergency, the state has not yet implemented these changes. Our best guess is that it won't be implemented before July of 2021, but we are unsure of exactly when it will be. We're waiting for official answers from the Department of Health on when they think it will be implemented. So we're in a very gray area for Medicaid home care right now. And again, it's another reason to get your estate plan looked at to make sure that if this is something that's part of your plan and something that you were thinking would be needed in the future, that you're aware of how these changes in the law will affect the planning that you have done or that you plan on doing. The other big change is in how they determine the number of hours that will be applied to someone who has become eligible and approved for care. So when you apply for Medicaid home care, you first apply and receive a financial determination. That's what's changed with the 2.5-year look back. And then there are certain assessments that happen to determine how many hours of care Medicaid will give to you, and it's based on need. One of the other big changes in the law is that they're changing the threshold question of who is eligible for Medicaid long-term care in the home. And they've changed the system of how the hours that will be provided are determined. Now, we don't have final answers on how those assessments are going to go. And I was actually just on emails this morning where proposed regulations about that have come out, and we're parsing through and commenting on them. So we're going to have to wait and see how it's going to play out. But what we do know is that the threshold question of who will get long-term care in the home is now going to be tied to the number of activities of daily living that you can or can't do on your own. Part of what's going to be determined is exactly how activities of daily living are defined, but you can think of it as bathing, grooming, eating, transferring to and from a chair or to and from a toilet, going outside, shopping. These are the activities of daily living that if you need assistance with these activities of daily living, you will get care in the home. Now, right now, there is no requirement that you need assistance with a certain number of activities in order to get care. However, that's going to change. Once these new regulations come into place, and we again don't know when that will be, if you can't, you will need assistance, physical assistance with 2 or more activities of daily living in order to receive care at home. If you have, 3 or more activities of daily living, physical maneuvering, if you need assistance. And so that means that somebody who just needs assistance with bathing and dressing won't apply. You will need more assistance, to have more assistance than that in order to apply. Now, if you have a diagnosis of Alzheimer's or dementia, they are saying that you will only need assistance with 2 or more activities of daily living, and that could include supervisory assistance. So physical assistance with 3 or more if you don't have dementia or Alzheimer's, 2 or more with supervisory assistance if you do. So that's good news for those with cognitive impairments brought on by dementia or Alzheimer's. Although one of the things we're concerned about is it leaves out a lot of people that have cognitive impairments that are brought on by other illnesses. And one of the things we're looking to do is to get that expanded so that those with traumatic brain injury, stroke, and other types of illnesses that bring about cognitive impairment will be taken into consideration here as well. So again, these are things that are going to be changing in the future, but we don't know exactly when that will be. So keeping in close contact with your attorney and other advisors is going to be important to make sure that you're on the way to what you need in terms of your own estate plan and protecting you and those you love and the charities you care about and whoever it is that you're leaving assets behind to. So what does that mean you should be doing now? I think I've made it clear throughout, you should be planning. And if you've planned, you should replan and you should be reviewing. And I thank you very much for having me today. I will take questions. As Liz said, there's a Q&A box on the bottom of your screen or in the control panel. And so I'll be here to take questions for as long as they're coming in. And I am going to start.
We do have one question. It says, am I also exempt if the deceased lived out of state, but I reside in New York State? VA is where the deceased lived.
So I think this is probably referring to estate taxes. The estate taxes on an estate are based upon the state in which the deceased person resided. So for example, if someone died living in New York and, living in Virginia, and the beneficiaries are in New York, the estate taxes will be applied based on the federal government's rules and then the Virginia state estate taxes. So you'll have to find that out. There is no what we call inheritance tax in New York. So the tax isn't on the individual who's inheriting, it's on the entire estate of that person that passed away.
Thank you. Next question. I just read in my AARP magazine that a joint will is a bad idea. Is this true?
That's a good question. I agree. I've never, ever drafted a joint will. And I have in very few cases and very specific set of circumstances drafted joint trusts. We don't believe, similar, I guess, to AARP, we don't believe that they best serve people's concerns. You don't know who's going to die first. It locks people in as soon as one of the two people have died in a way that leads to a lot less flexibility. And so we do not recommend joint estate planning documents. Now, that doesn't mean that married persons shouldn't have coordinating estate planning documents that complement each other and that take place and are a cohesive plan, but a joint document is not something that we're ever going to recommend.
Thank you. Next question. Should I place my two houses in trust?
So that's a good question. I can't answer if you should do it, but I can tell you the things that you should be looking into. And there are going to be a lot more questions and there'd be a lot more questions for you to determine if it was best for you. But the reason that a lot of people will put houses that they own into revocable trusts to avoid probate are a few reasons. One is if you collect rents, say, on those houses, if you live in one and you rent the other out, upon your death, if probate is going to take 6 months, 12 months, with COVID, we see probates that are going on and on because the courts can't get the information they need because they're not open at full capacity yet. We see delay in estates, which means there's a delay in control of those properties. We also see people who want to sell properties in an estate and can't do so because without the probate being done, there's nobody with the right to sell the property. And so you run into a situation where you're continuing to pay taxes on the house and the upkeep and the maintenance, and you've got a buyer who doesn't want to sit around and wait because there's nobody to sign off at closing. And so a lot of people who own multiple properties want to put them in trust because the trust will provide for who immediately will be successor to you as trustee if you become incapacitated. And if that's the same person upon your death or whomever it is, it immediately puts that person in power without the delay of waiting on the courts and perhaps fighting amongst beneficiaries and whatever else may happen in order to get those properties taken care of and in the control of whomever they're going to.
Thank you, Britt. I don't see any more questions. Just as a reminder, there is that Q&A. I guess we'll just stick around for a few more minutes to see if any other questions come up.
I think that might be it. Well, thank you everyone so much for joining us. We hope to come back again soon, and hopefully you can all visit us in our offices on Main Street in Westhampton Beach. We're right next to the Performing Arts Center. And I hope you all stay warm and have a great day.